microphone, except for Tim. Well, good morning or afternoon, everyone. So my name is Martin Vinke, and I'm the chair in citizenship studies at the EY, and I'm chairing the Global Citizenship Seminar Series, which is an informal seminar series, which we normally hold in Vidas Kivanoia, but we currently do this online, and that's too bad because we cannot meet in person, but it's of course very nice that we can have other people joining who could otherwise not join. And today we have a presentation by Timothy Jacob Owens. And Tim is a PhD researcher at the EY in law and also a research assistant at Global Cit. And Tim will talk about immigration and multicultural citizenship in Europe. And he will talk for about 20 minutes. I will tell you once your time is up. And then we have about half an hour for Q&A. So without further ado, I suggest that you take the floor, Tim.
Okay, great, perfect. Thanks, Martin. I'll just share my slides. Can everyone see those? Is that working right? Great, okay. So thanks very much to Martin and Jelena for the opportunity to present in the seminar series. So this paper has kind of grown out of my PhD research, which is on the topic of linguistic justice and immigration in Europe. But it also draws on some other material that's not in the thesis, and I'm hoping it might eventually become a publishable standalone article. But that's very much up for discussion, and any and all feedback at this stage would be very much appreciated. I'll start with a little bit of conceptual background to how I'm framing the analysis, talk briefly about methodology, and then move to the analytical part, which, as in the written paper, is divided into two parts. So in the first part, I'm focusing on the kind of broad question of whether groups of immigrant origin are granted any kind of multicultural citizenship under the Framework Convention for Protection of National Minorities. So in legal terms, this is a question of whether groups of this kind fall within the treaty's personal scope of application, which basically turns on how we define this term of national minority. And then in the second part, I'll look at the content of multicultural citizenship granted to these groups under the treaty, so the scope of protection, that they can claim. So this term multicultural citizenship was, of course, famously used by Will Kymlicka to refer to his theory of minority rights. And as I'm sure everyone here is well aware, the basic idea is that the kind of universal, uniform rights of liberal citizenship should be supplemented with additional, more far-reaching protection for non-dominant cultural groups. And Kymlicka, as is well known, argued that this additional protection should be group differentiated. And in particular, he argued that what I will refer to as a strong form of multicultural citizenship should be reserved for historical or old or indigenous groups. And this features, among other things, the promotion of the language and other cultural characteristics of these groups within the public sphere. And by contrast, he argued that groups of immigrant origin, so more recently settled groups, should only receive a weak form of multicultural citizenship, which might include certain forms of accommodation for cultural practices, but wouldn't go as far as the promotion of their cultures in the public sphere. And this remains 25 years later, basically still the dominant view in theory and practice, and we see this reflected in many domestic systems in Europe and elsewhere. And the question that I'm trying to address in this paper and also in my PhD more broadly is whether, in fact, at least some groups of immigrant origin should perhaps be granted stronger forms of multicultural citizenship. So Kymlicka subsequently wrote about the recent phenomenon of the internationalization of multicultural citizenship, which has taken the form, among other things, of the codification of minority cultural rights in international treaty norms. And what this development means is that the question I've just posed is no longer a matter solely of normative theory and domestic practice, but also a question of international law. And this is the perspective I'm adopting for the purposes of this paper. So in the European context, the key reference point here is the Framework Convention for the Protection of National Minorities. So this is a treaty that was drafted under the auspices of the Council of Europe in the mid-90s, early 90s, and has now been ratified by 39 states across the continent. And from a kind of global perspective, the Framework Convention is also an important reference point because it remains probably the most ambitious attempt to codify in detail minority cultural rights in binding treaty forms. In the literature so far, there's a presumption that insofar as the Framework Convention grants any form of multicultural citizenship to immigrant origin groups, it would take the weak form that I've just described. But this presumption has so far been untested in practice. And what I mean by that is that it's been developed in the abstract and without reference to the actual concrete practice that has been developed in the application of the treaty to groups of this sort. So this is the kind of gap I'm trying to fill basically with the paper. I'm trying to offer a kind of systematic analysis of how this treaty has been applied to groups of immigrant origin. So this is supposed to be a kind of purely doctrinal piece, so no regressions or graphs or anything like that. So apologies to those who are into that kind of thing. Hopefully it will be bearable nonetheless. The focus is in particular on how the treaty has been applied in the Czech Republic and the UK, for the simple reason that these are the only two state parties to have so far expressly opted to apply the treaty to immigrant origin groups. And the two key sources for the analysis then are drawn from the treaty monitoring procedure. So we have reports that are submitted by the state parties every 5 years, where they set out how they consider that they have fulfilled their treaty obligations. And then we have opinions issued by the Advisory Committee on the Framework Convention, which is an independent expert body that was established under the treaty. Okay, so with this in mind, I'll turn to the first part of the analysis, so the question of whether groups of immigrant origin are covered by the treaty at all. So as some people may know, the Framework Convention doesn't actually define the term national minority. And the reason for this was that the drafters were unable to agree on a suitable definition. So if we look at the preparatory works, which I've quoted here, we can see that precisely the issue of whether groups of immigrant origin should be included was a source of contention at this stage, and ultimately no agreement could be reached. So instead, it was decided that it would be left for each individual state party to decide for itself how it would understand the term national minority and thereby determine to whom the treaty should be applied. So as I've already alluded to, the vast majority of the states parties have so far opted to exclude groups of immigrant origin. Many of them have adopted a definition or a set of criteria by which they identify their national minorities. So I've quoted here the definition adopted by the Netherlands, which is perhaps of particular interest to some people here, but it's also a nice kind of representative example of the kind of typical approach under the treaty. So there are two aspects of this that are important for the purposes of this paper. So firstly, the Netherlands, like the majority of other states, restricts the notion of national minorities to groups of citizens. So it makes Dutch citizenship, formal citizenship, a kind of precondition for the enjoyment of multicultural citizenship under the treaty. And then secondly, the Netherlands also has this requirement of traditional residence and residence in a traditional or ancestral settlement area. And this clearly has the effect of excluding most, if not all, groups of immigrant origin. And indeed, this is how the Netherlands interprets these criteria. So it states that only the Frisians, who of course are a historical group in the Dutch context, fulfill these criteria and therefore constitute a national minority. And this kind of practice is reflected in most of the states. However, so we have a couple of exceptions, as I mentioned. Firstly, the Czech Republic, which actually initially had a very similar approach to the mainstream. So this was the definition it originally used, and which, as we can see, includes both the criterion of citizenship and the requirement of a long-term, solid, permanent relationship with the Czech community. The approach changed a little bit with the introduction of a new definition in a 2001 law on the rights of national minorities, which includes both the citizenship criterion, but where here the sort of historical ties criterion, as it were, is formulated in slightly looser, vaguer terms, which potentially invites slightly more inclusive interpretation. In practice, it's understood that only those groups that are represented on the Czech Government Council for National Minorities are considered to be national minorities for the purposes of this domestic legislation, but also for the purposes of the Framework Convention. And the membership of the Council then has expanded over the years. So initially, when the Czech Republic first ratified the Framework Convention, only historical groups were represented. But then in the intervening years, more recently settled groups have been added, notably including the Vietnamese minority in 2013. So this is a kind of perfect example of a group of immigrant origin. It's established solely through post-war labor guest worker migration, and is the first community of Asian origin to be recognized as a national minority in Central and Eastern Europe. The approach of the UK has been even more unusual and inclusive. So when the government first ratified the Framework Convention, it said that it considered the term national minority to correspond to the notion of racial group in UK anti-discrimination law. So at the time, this was defined in the Race Relations Act 1976, and as even a superficial reading of this definition makes pretty clear, this is a very broad notion and covers more or less any immigrant origin group you could think of in the UK context. And this was the express intention of the UK government that set out in its first state report that the definition includes its ethnic minority communities. So finally, on this point then, I'll just briefly turn to the views of the Advisory Committee, which has repeatedly addressed the issue of the Framework Convention's overall scope of application, notably in a 2016 thematic commentary that was specifically devoted to this topic. So on the issue of the criterion of formal citizenship, the Advisory Committee said that this can have restrictive and discriminatory effects, and argued that it shouldn't be used as a criterion for the application of the treaty as a whole, though perhaps it could be used for individual provisions. And it made very similar comments in relation to the notion of historical ties or the use of some kind of residency requirement, as in length of residency for a group as a whole. So again, saying here that this shouldn't be considered a determining factor for the applicability of the treaty taken as a whole. So taken together, these two statements seem to suggest that the Advisory Committee would favour the inclusion of immigrant origin groups within the treaty's scope of application, and indeed this is borne out in its monitoring practice. So for instance, in its second opinion on Germany, it expressly stated that many Turkish and other people with foreign background could benefit from certain rights covered by the Framework Convention. I should say Germany has taken an approach very similar to the Netherlands, such that Turkish and other people with foreign background are not currently included. So this leads then to the question of precisely which rights covered by the Framework Convention would be enjoyed and are enjoyed by groups of this sort. So the substantive provisions within the Framework Convention are often construed as a catalogue of rights that are applied on an article by article basis to different groups depending on their circumstances. And I've categorized the provisions into these three under these three headings. So a number of them deal simply with general human rights norms, and these unsurprisingly have a broad scope of application, so apply to all groups brought within the treaty's overall scope of application. Then there are what I've called here weak minority rights, which go beyond the substantive scope of human rights norms, but do not go as far as the public promotion of minority cultures. And these likewise have a broad scope of application. And then there are a few what I've called strong minority rights norms, which do deal with the public promotion of minority cultures, particularly minority languages, and these then have a more restricted scope of application. And I take these weak and strong minority rights to correspond to the weak and strong forms of multicultural citizenship. I'll just go through briefly how these have been applied to immigrant origin groups. So they say there are various human rights norms that are simply reiterated in the Framework Convention's provisions. Some of them are very obvious. They're really just a kind of word for word restatement, things like freedom of expression, freedom of assembly. There are also a couple of seemingly novel rights, like the right to use a minority language in public and private, which is actually just a more explicit restatement of the protection entailed by freedom of expression. So unsurprisingly, these all apply uncontroversially to groups of immigrant origin. They would apply anyway as a matter generally of international human rights law. And so I just picked out one example here, the UK recognizing explicitly that members of ethnic minorities have the right to use their minority language freely and without interference under Article 10.1 of the Framework Convention. Okay, so turning then to the weak minority rights, these deal generally with things like facilitating access to mainstream institutions, like the media and education, and certain kind of limited support for the largely private maintenance of minority cultures. And again, as I say, these have a broad scope of application, so they expressly apply to all those brought within the treaty's scope of application. And this again is reflected in the monitoring practice. So I'll just pick out again a few examples. UK under Article 12 has talked about measures to support access to education for minority ethnic groups. The Czech Republic has talked about grant funding under Article 5 for the preservation of Vietnamese culture and identity. And the Advisory Committee, again under Article 5, has recommended that the UK provide funding similarly for minority ethnic language and culture. So turning finally then to the strong minority rights provisions, is where it hopefully gets a little bit more interesting. So 3 of the provisions deal with the promotion of minority languages in the public sphere. Article 10.2 provides for the use of minority languages with and by public administrative authorities. Article 14.2 provides for minority language education in public schools. And Article 11.3 deals with public signage in a minority language. And as I mentioned, these provisions all have a more restricted scope of application, so their applicability is subject to certain restrictive conditions, and in particular, the criteria of substantial numbers and traditional settlement. In the case of Article 10.2 and 14.2, these conditions are alternative, meaning that a group only has to fulfill one of the 2 in order for the provisions to apply. And in the case of Article 11.3, these are cumulative conditions, so a group has to be present traditionally and in substantial number in order to claim protection under this provision. So unsurprisingly, perhaps the prevailing view is that these provisions simply wouldn't apply to groups of immigrant origin, and this corresponds, of course, to the kind of broader view that they should only be able to claim a weak form of multicultural citizenship. In reality, the kind of monitoring practice in relation to these provisions and their application to immigrant origin groups has been a little bit more complicated than that. So under Article 10.2, the Czech Republic has talked about the use of Vietnamese, for instance, by administrative authorities, so reporting here on the printing of voter information in Vietnamese. The UK has expressly stated that persons from ethnic minorities may use their own language in contact with administrative authorities. What it's referring to here largely is the provision of translation and interpretation for access to healthcare and other social services. The Advisory Committee has also recognised the need for language and communication support for minority ethnic groups in its Article 10.2 monitoring. So it seems then that all 3 of these actors do consider this provision to apply in respect of immigrant origin groups, but it's worth noting that the Advisory Committee in particular has been much more far-reaching in its recommendations vis-a-vis historical groups. So I've quoted here a recommendation in respect of the Cornish minority in the UK, and the Advisory Committee has gone as far as to suggest that the UK should adopt a Cornish Language Act. So no similar kind of recommendation has been made compared in respect of immigrant origin groups. We see a similar pattern in relation to Article 14.2, so dealing with minority language education. Czech Republic has talked about funding for the teaching of Vietnamese. The UK has referred to the possibility for schools to teach heritage languages of minority ethnic pupils. And the Advisory Committee has consistently encouraged the UK to expand provision for the teaching of minority ethnic languages in schools. Again, we can see more far-reaching recommendations being made in relation to indigenous languages. So the Advisory Committee has talked not only about the teaching of, but also in this instance, Gaelic and Irish, which are indigenous languages in the UK context. And finally, perhaps unsurprisingly, neither the Czech Republic nor the UK have talked about measures under Article 11.3 for immigrant origin groups, so dealing with minority language signage. But the Advisory Committee, in its most recent opinion on the UK, did refer to the installation of English Bengali signage in part of London. And this seems to hint at the idea that it does consider that this provision can apply to at least some groups of immigrant origin. Again, I've just included a quote which shows that it's been sort of more forthright in relation, for instance, to English and Gaelic signage. Okay, so to briefly conclude then, we've seen that on the whole, immigrant origin groups are denied any form of multicultural citizenship under the Framework Convention, given the fairly restrictive understanding of national minority adopted by most of the state parties. And in the 2 exceptional cases of the Czech Republic and the UK, we've seen then that the presumption that the Framework Convention only grants a weak form of multicultural citizenship to immigrant-origin groups doesn't seem to be fully borne out in practice. So at least these three more restrictive provisions dealing with stronger minority rights have been applied to groups of this sort. But then the advisory committee in particular seems to consider that the obligations stemming from these provisions are more far-reaching in respect of historical groups than in respect of immigrant-origin groups. And I'll just finish with a kind of open, though rather leading question as to whether this is justified. And given the scope of the paper, I'm really particularly interested in whether this is legally justified. It seems to me it would have been more straightforward to simply treat these articles, these provisions, as not applying to immigrant-origin groups, full stop. And by then applying them, but only in a kind of perhaps half-hearted way, the advisory committee in particular has opened itself up, in my view, without any further justification to potential criticism for drawing kind of arbitrary and potentially discriminatory distinctions. But I'm happy to speculate a bit more about that in the Q&A if people are interested. I'll leave it there, and thanks very much for listening.
Excellent. Many thanks, Tim, for an excellent paper. I really enjoyed reading your paper, and also for an excellent presentation, and very well timed. So it leaves us plenty of time to open up for discussion. If you want to ask a question, I think you can just wave on the screen, or if I somehow miss you, indicate this in the chat. And I suppose we can just take this one by one. And I saw already René de Groot waving from Maastricht. So I'm happy to give you the floor first, René.
Yeah. First of all, I repeat again what I said already before. It's an excellent paper. It was a very, very, very good presentation, Timothy. And I think it came on a perfect moment this year, because we have to realize that there are three conventions of the Council of Europe dealing with linguistic justice, as you said before. The two other conventions are the European Charter for the Protection of Regional and Minority Languages, and then there is also the treaty, the Charter on local self-governance, and also this treaty, the European Charter of Local Self-Governance, that's the oldest convention from 1982, if I'm not mistaken, pays also attention to communication in other languages than the main official languages of the state with the authorities, and between the authorities and people living on the territory of certain local and regional entities. And it is important, and perhaps you saw that already, that the monitoring body under the Charter of Local Self-Governance came with a recommendation of the use also of immigrant languages in October of this year. And actually, I have to admit, I made the draft for that recommendation. Then I want to devote a couple of words on this European Charter for the Protection of Regional and Minority Languages. The European Charter of Regional and Minority Languages is a bit older than the Framework Convention. They were negotiated at the same time, but it was concluded already and open for signature in 1992, and the Framework Convention only in 1995. And it is quite striking that the scope of applicability in respect of languages between the Framework Convention and the European Charter on Regional and Minority Languages differs. You gave already the example of the Netherlands. For the Netherlands, it's only Frisian made applicable for the Framework Convention. And originally, it was also planned that only Frisian would be protected by the European Charter on Regional Minority Languages, but then it was broadened up. Two non-regional languages were taken on board, being Yiddish and Roma and Sinti. And as regional minority languages, also Lower Saxon and Limburgish were taken on board. But strange enough, these are not covered by the European, by the Framework Convention. And there, everything focuses only on Frisian, although also in respect of the Lower Saxon people and the Limburgish people, one could say they are traditionally present on a part of the territory. It was also very interesting that you mentioned that the advisory committee made remarks on the Moluccians. Obviously, the South Molucca community approached the monetary body of the Framework Convention, but they did not approach the monetary body of the European Charter on Regional Minority Languages, which is quite striking. However, one can see that the Papiamento community did contact both monitoring bodies. And why it is interesting to see these differences between the scope of application. It is absolutely true that all these three conventions are dealing with the question what to do with the language of immigrants. And what you did not mention in your presentation, but it is mentioned in the paper, is that the traditional approach of all three bodies was it must be a language spoken on the territory of the state by nationals of the state for a period more than 100 years. But we can observe that quite a lot of these migrant communities, in the meantime, are already on the territory of the country, let's say 70 years, of 60 years. Therefore, it goes in the direction of the 100 years, at least during the time of your career, your future career. And therefore, the point is, when do we change that approach? Therefore, it is absolutely important that you gave this presentation, and the paper should be published as soon as possible. There's one other point I want to make, and that is the point of the synchronization of the monitoring process of at least the Framework Convention on the spot visits and the European Charter of Regional and Minority Languages. And I'm sure that you know that already, but it is very informative for the other people listening to our discussion. It is decided by the Council of Ministers in June 2019 that the synchronization of the on-the-spot visits will take place. Therefore, the monitoring process will be coordinated. And that makes it very likely that the approach of the one monetary body will also have an influence on the way how the other monetary body will raise questions and the views taken by the other monetary body. And then precisely this discrepancy between the scope of languages covered by the one convention and the other convention gets very, very striking. And also the monetary body, the Committee of Experts of the European Charter of Regional and Minority Languages, will have to think about the approach taken by the advisory committee in respect of at least a partial application of some rules of the Charter to the migrant languages. I hope that you also will pay in another paper, or at least in your PhD, attention to these discrepancies and take on board also in particular for the Czech Republic and the United Kingdom, what the other monetary bodies did say. And for example, the example of Cornish was also raised during the on-the-spot visit of the Committee of Experts in the United Kingdom. And the other point of, you mentioned in particular to Northern Ireland and Scotland, they were also discussed in the context of the other monitoring body. And perhaps it is good for you to know that I was one of the 3 members of the committee of experts visiting the United Kingdom for the on-the-spot visit. Okay, I think that's for the moment enough. It's more an extra comment than criticizing anything. I think there's nothing to criticize in your presentation. It is really excellent. The only point you should make very clear is what kind of conclusion do you want to make? I agree with you, it would be easier to say the migrant languages are not covered. That's the easiest position. But you also have to take on board that during the next 30, 40 years, if one follows the definition more than 100 years present, will be fulfilled by quite a lot of these nowadays still immigrant languages. Therefore, you have to create already an opinion what you want to defend if you have my age.
Okay, thanks a lot, René, for sharing your thoughts on your experience and pushing Tim on both the generalization of the argument relating to the other conventions and also the pushing him on the conclusion. So maybe Tim, you can give some thoughts.
Definitely, yes. So thanks very much for all of that. And there's a lot in there. I'm not sure I can say very much, but it's very nice to have your feedback. And so one thing very briefly, I didn't know about the recent opinion from the Charter of Local Self-Government relating to use of immigrant languages. So that's very useful to know, and that will definitely make it into the PhD. On that note, so in the PhD, there's a chapter that's partly about minority rights generally under international law, and so I do deal with the language charter also in that context and how it's been applied. In terms of this question of what conclusion am I trying to draw, that's definitely, I'm not quite sure yet, and I'm aware it's the weakest part of both the presentation and the written paper. So I mean, as I say, it's work in progress. I'm not quite sure. What I was struggling with a bit with writing it is that because it relates so closely to my PhD, and in the PhD, there's also a kind of political theory dimension, and I'm trying to defend a kind of normative stance that is in favor of precisely this thing of expanding the scope of these treaties and generally expanding the scope of language rights to groups of immigrant origin. But then with this, I'm trying to make it a pure doctrinal thing. And so I'm sort of trying to steer this course where I'm attempting not to make my personal views on the subject clear, or at least, trying to give a balanced legal view rather than arguing for a strong normative stance, which maybe isn't the way to go. I don't know. And I felt as I was preparing this, I was thinking increasingly maybe the thing to have done would have just been to try and present it all. I don't know. But I think for me, there's something in the idea of trying to draw out in a descriptive way the way the treaty has been applied. And perhaps the more useful conclusion is precisely as you say, to think this is an indication of how it has worked so far. And if indeed we are going to be in a position in decades to come where increasing numbers of groups of this sort are brought within the treaty scope, then thinking that the advisory committee needs a coherent position on how to apply the treaty to these groups. And that to me has been lacking so far. So I guess that would be something I'd like to try and work through more clearly and coherently myself and try and have a clear stance of that. Well, I don't know if that's an immediate reaction.
Thanks, Tim. Well, I have some comments or questions, but are there any other, Lily, Jelena? Maybe we can take a couple. Lily, you want to go first? I will put myself a bit later in there.
So I'll start by apologizing because I was so eager to sign up for this workshop. I signed up before it was over Zoom. So that put me off of the email that had your paper attached to it, which I only realized when I couldn't find the Zoom link this morning. But your presentation, from what I was able to read of the paper before joining, seemed very thorough and detailed. So I hope I'm not asking something that you've covered already, but my question is related to this issue, not really issue, but question of what you want to conclude with, and what is sort of some of the takeaways from the paper. And what I kept asking myself was kind of what are the major implications of getting strong minority rights? You highlight the issue of language in particular, but I wonder if there's something more to that that kind of helps to give a sense of why it's so, you know, in some ways it's obvious, but maybe just spelling it out a bit more, why it's so important, you know, how these minority groups fit into these frameworks and kind of the implications for people's actual lives, and not solely from kind of this legal standpoint, might help to kind of flesh out maybe some policy implications, or a little bit more of a sort of this so what question in the introduction and conclusion, just in terms of maybe framing. And then I also was wondering about any countries that the treaty that they're applying the treaty non-expressly, because I noticed you were saying that these are the only 2 countries that have expressly applied this to immigrant minority groups, but I wondered if there are any falling into this non-expressly category and what that might look like, and if that could help to kind of color some of the ideas for maybe the conclusion. And thank you for this great presentation.
Thanks, Lily. Let's do it one-on-one. So Tim, maybe you can respond, and then we go to Jelena.
Sure. Yeah. So thanks very much. And I definitely take the so what point on board. And yeah, I think I feel like it's developed a little bit. You know, there's quite a kind of in-crowd sort of literature of people who are really into the treaties and how they're applied and stuff. And I feel like I'm sort of on the edge of that and kind of looking in and thinking, oh, how can I contribute to that? And I think one of the nice things, and something I wanted to get out of presenting as part of this seminar, is also the kind of why should anyone else care sort of thing. And I don't think I haven't got there, but I agree it's definitely something that needs to be addressed, and the conclusion seems like an obvious place to draw it out. So I'm not sure I have anything useful to say directly, but I'll bear that in mind. On the non-expressly thing, yeah, so this was a sort of trying to get around the fact that there are, and you know, maybe I will need to expand the scope of the analysis a little bit. So there are a few countries, and in the written paper I do mention, so Russia is one of them, Ukraine is another, where they have a slightly strange stance. That's, so I think in the Ukraine, from memory, it's anyone who identifies as not Ukrainian is a national minority kind of thing, which is fine, but they also haven't said, so therefore immigrant group XYZ is included, and we therefore apply these articles and blah. So so in principle, one could infer from their approach that I move to Ukraine tomorrow and I form a little English national minority by myself, but I'm not sure what that would really mean. And it's at least not as sort of explicit. That was what I was trying to get at with this expressly thing, as the UK or Czech Republic going, here is this group that we apply and blah, and this is what we've done, sort of thing. So that's, yeah, that's that. But I think it's a little bit, could do with probably spelling out a bit more.
Well, thank you. And I think it is, I think the so what isn't, you know, entirely hidden, because obviously having access to these rights and having them expressly granted, which I now see the distinction, it has a bit of an obvious importance, but maybe just in thinking through that could help to kind of help with the framing and the conclusion.
Definitely, yeah. Thank you.
Thanks, Lily. Jelena.
Thank you so much, Tim. I think that this is a fascinating research area, and I think that what you will eventually come up with will be a brilliant paper. But similar to Renee and Lily, I'd like to, in a way, try to push you to think of an argument that's going to move a little bit from this descriptiveness. And it may be perhaps disciplinary differences, as I know that sometimes in legal scholarship, descriptive papers are in a way, well, not common, but more frequent. But what I really think but I really think you should use this paper as an opportunity to put forward a stronger claim. Now, when I was listening to you and also thinking about your paper more generally, I thought of a couple of things. It's one thing that strikes me is that in many of these international also legal instruments, the area of rights is very well defined. What I seem to be missing is the definition of essence, who it applies to. So, and I think that this is the question here, because defining national minorities is usually outside the scope of these kind of conventions. And this, in a way, brings me to what Lillian mentioned and what you mentioned, the countries where the Framework Convention does not apply expressly to immigrants. If you think about Eastern European countries, and I've looked at a little bit at their constitutions, etc., in most cases, or in many cases, national minorities are defined constitutionally, meaning that there are, in a way, let me put it like this, structural limitations to applying this convention to other communities. So I was wondering whether this could be an interesting line to pursue, meaning the different scope of application of the Framework Convention in view of restrictions within the national context. So that's one thing. And the second thing is I was wondering what would be the, let's say, broader some socio-economic factors why the UK and the Czech Republic would, from among all the signatories, would apply expressly the convention to their immigrant communities. I'll leave it at that. Thank you.
Thanks, Jelena. Tim.
Okay, yeah, thanks very much, Jelena. Briefly on the stronger claim, maybe if I can. So, like, as a little bit of background, I suppose, this kind of started as my LLM project. And that project was, in principle, just like the scope of application of minority language rights under international law. And what I wanted to do was to make an argument, like a legal argument, and say, oh, as a matter of international law, these rights should also be applied to migrant groups. And in the end, it was all quite unsatisfactory because I'm not sure you can really make that argument, though I want to make it. And so that's why I ended up doing the PhD, and well, it's not the only reason, but the PhD is then an opportunity to kind of elaborate the argument that I really wanted to make, which I think has to be made by reference to political theory and whatever ideas, more abstract ideas about justice and whatever, which is what I'm trying to do. And I suppose with this, I kind of feel like maybe there is still some value in the kind of boring law descriptive thing that has more kind of maybe technical value, even if it isn't, me really putting out my views of the world. Also because those are less well developed. I guess that's also part of it. Like this, I feel I'm reasonably on top of, and hopefully there'll be something that comes out of the PhD that's more me, but like, I don't know. So this also is a sort of interim step in a way. But I can see the appeal of trying to put something stronger in there. So then specifically, yeah, so I think this thing of how the Framework Convention applies differently in different states depending on domestic constraints is really interesting. One thing in terms of the like East-West Europe comparison, which you sort of alluded to, what I quite like the fact that the Czech Republic is one of the two states, because it does at least mean that and certainly if it were just the UK, then it would be kind of like, oh, well, the UK is sort of weird anyway. And, so I think it's quite nice that there is a state with a more kind of standard continental and also Eastern European kind of history and stuff, which then also links to sort of why these two states. So the UK, I go a little bit into this in the written paper. I think the timing has a lot to do with it. So because the Framework Convention emerged in, what, as Renee said, the mid-90s, but the UK was ratifying it in 1998, 99, and that coincides with public inquiry into institutional racism in Britain. And from the parliamentary kind of stuff around that time, there are these statements where they say, oh, well, we're going to sign up to this because it shows our commitment to tackling racism, which is sort of, in a way, you could see that as being completely missing the point of the instrument, but that was how it was framed and how certainly the first report is written referring to that inquiry and stuff. So I think that was a kind of slightly weird quirk of the timing, maybe also just the convenience of racial group existed as a legal term in UK law, which national minority doesn't, and it wouldn't be an obvious thing to kind of, it would have required quite a lot to integrate that. It's also linked to something, so Bruno De Witte, who isn't here, but who I've chatted to quite a bit about this, he's raised this in the past, that the question of whether a country has a dualist or monist approach to international law has quite an impact, and in a way it's easy for the UK to go, oh, well, everyone's a national minority, that's fine, because nothing really in terms of the domestic law follows from that. No one can litigate this and say, oh, you've violated my rights. Whereas in the Netherlands, as I understand it, that would be the case. It has a monist approach to international law, so that it would be a much more concrete consequences from that, legal consequences from that, which I think probably then explains why quite a few of the states haven't adopted that approach. And these, as I'm sure you know much better than I do, the Framework Convention is included much more, is one of these several treaties, I think in the Bosnian context, maybe among others, that's like mentioned in the constitution and has quite a significant domestic status as well. So if you suddenly start including more groups, then it would have an impact. Although, as I mentioned in the written thing, there is a reference to the fact that the Bosnian authorities have been talking to the Syrian and Palestinian communities about inclusion. So yeah, who knows where that would go, but yeah.
Thanks, Tim. Let me just ask you a question, and I give you the floor later, Renee, okay? So Tim, I really enjoyed reading the paper, and I found it extremely informative and interesting, and you cover actually a lot of ground. From my maybe layman's perspective on this, since I'm not a lawyer, I think that it looks already very well developed. So I would certainly not change it completely. If you want to do other things, do that in another paper. It seems to me that this is a really well crafted paper. And I really enjoyed reading it. So two things came up when I was reading this: one question of curiosity and one more on the point of the overall conclusion and argument. So the question more out of curiosity would be, why did the Czechs decided to extend these rights also to the Vietnamese? So it would help. So it's out of curiosity, but maybe also for the argument, it's important to understand a bit what was behind this in terms of the political mechanisms and what was actually meant, why the Vietnamese and not other groups. So they are, I suppose, one of the most historical post-war extra-European migrant communities in the Czech Republic. I think it would help if you would say one or two things about that, just to clarify the context. And then the second comment would be on the conclusion, and I wanted to pick your brain about what you thought about trade-offs, between personal definition and scope, because it seems to me that maybe your question, to what extent do these rights also apply to immigrant communities, involve a trade-off, right? So we can enlarge the personal scope, bring in immigrants, but maybe that comes at the price of restricting the scope of rights that can be attributed. It seems to me that is maybe a more pertinent question than the question that you posed at the end of your presentation, whether this is legally justified. So at least empirically, you could say something about whether there are certain trade-offs in practice, right? So do you So, and in this case, I thought that particularly this, you mentioned this, in a way, the strongest right. So Article 11.3 on public signage. Yeah, do you see some kind of, is there some kind of a trade-off consideration in states, and maybe also, right? So the advisory committee can of course push, right? So I see that they push on bringing in some of these, on enlarging the scope and also bringing in immigrants. And so that it seems to be that is a process that might be evolving, right? Also because, as René says, you know, over time, simply immigrant communities, long-standing immigrant communities will become historical minorities, right? If you wait long enough, and you don't have to wait, I think, until you are as old as René. So that is something that is already taking place. Yeah. That might come, of course, at the cost of actually being more reluctant to extend the full scope of rights that we could imagine. And it would be interesting to see if you already see some of the nascent dynamics. Let's say our states indeed becoming a bit reluctant to extend those rights. And of course, the strongest form of that would be if you would actually see a backlash with regard to the more established national minorities, right? If the scope, the extension of the personal scope comes at the price of extending these strong rights to even the national minorities. I don't think you signal that in the paper, but I would be interested to see if you see anything about that. Thanks.
Okay, great. Thanks very much, Martin. So the first question about, yeah, so I don't speak or read Czech, so my understanding of the Czech situation is limited to like a few articles that I cited in the thing that are written in English. But my understanding from that is that I think the key thing is that there was some mobilization within the Czech community, and there was an active request made that they be included with it, you know, within the council, which then gave them the access to the treaty protection. This links a little bit to something that René said and I failed to pick up on, which I think is a really interesting dynamic that I'm also trying to look at in the PhD, is the like civil society mobilization in relation to these treaties, and where the kind of strategic choices made as to which treaty bodies they try and engage with. And I think this is something, I think that this is just speculation, probably explains some of the differential approach to different groups, is that whereas just from a practical perspective, the Secretariat in Strasbourg and the experts are well networked, I think, that René can correct me, with, you know, established groups, say, Welsh civil society in the UK context and Cornish and so on. I don't think they have the links with equivalent civil society groups generally, is my impression. So as I understand it, a Polish community met with the advisory committee on the most recent visit in the UK, and they may also have met Vietnamese groups in the Czech Republic, but on the whole, these groups are perhaps less engaged with these mechanisms, which maybe then also links to the Yelena's question about why not in other scenarios. It may be that there isn't the connection there. Yeah, and then so the conclusion and the trade-off, I think, yeah, this is definitely a very pertinent issue. And I suppose what I'm trying to get at, but I think this is a sort of, I haven't really properly got this in my head sorted out yet, but it seems to me that, so you could have this kind of more practical, maybe economic sort of consideration about, okay, if we really keep expanding these things, then not everyone can have a sign in their language and so on. And it seems to me that the text of the treaty can be read in a way that allows for making that trade-off simply, but you'd say this traditional settlement criterion, you know, we'll say that that's 500 years, and therefore none of these groups can be protected under this particular provision, say. And that isn't what the approach that's been taken. And I think in a way it would have helped if you wanted to make that trade-off, as in if they wanted to make that trade-off, then it could have been done in a way that was at least more faithful to the text of the treaty by simply not applying those provisions. And then this is what I was trying to get at with this question at the end, is that by going part of the way there, for me, there's then what's the basis then for, because the trade-off I'm sure is there, but then what is the justification that's being offered for it, which is basically none. And I wonder, if it's more what's in the minds of those who are interpreting it and writing these things, whether it's from a practical point of view, we can't demand this, but to me that it could be better justified by reference to the law, I suppose, because their role in this instance is to apply binding treaty norms and not simply give policy advice, even though that is kind of in practice what they end up doing.
Okay, thanks. I know Renee wanted to come back to something. Is there somebody else who wants to bring in? Lorenzo, then I give you the floor first. If that's okay, Renee. Lorenzo, go ahead.
Okay, I'll go ahead then. Thanks a lot, team. I wish I could write and speak so clearly. Your paper and presentation were truly a pleasure to read and to listen to. So I'll try to make my train of thoughts equally intelligible, and maybe give you a suggestion for a more pessimistic conclusion. In the presentation, your conclusion was rather pessimistic. When I was reading the paper, I thought it was more optimistic. You were arguing more in that line of direction. So in the paper, you show that there are these two countries, of course, that apply the convention to minorities of immigrant origin, the Czech Republic and the UK. And you also cite a few other countries. So of course, I was very curious and I went to read the report of Switzerland, precisely because you mentioned Neuchâtel. It's quite rare to see Neuchâtel popping up. So of course, as a proud citizen of Neuchâtel, I went to check, and the Italian reports of the last few years. And I was quite surprised to see that there are, especially in the Italian report, a lot of references to initiatives directed towards migrant minorities, which fall under what you refer to as weak forms of rights. And so then I went to check the other reports, again, the UK and the Czech Republic, and perhaps in the UK you have some forms of strong protection towards minorities of immigrant origin. But not really in the Czech report. You try to cite a few in your paper, but those initiatives you can probably cite equally strong initiatives in Italy and probably in other countries as well. And so the conclusion, perhaps the question for you is whether the fact that the country applies the convention to a minority of immigrant origin actually has any consequence. I think you can make that argument perhaps for the UK, not so clearly for the Czech Republic. And that's my question for you.
Thanks. Renee, you want to jump in and then we give Tim the last floor?
Yes, two small observations. Tim made this distinction between weak and strong protection. And that reminds me to the division which exists under the Charter for Regional Minority Languages, where one has the basic protection of Chapter 2 and the elaborate protection of Chapter 3. And I think in future publications, in other papers, you should pay attention to that distinction as well in order to make your point under the Framework Convention. And then the issue, which happens frequently under the Charter, is that we have discussions on borderline cases of traditional presence or not. That can have two forms. For example, for Switzerland, there was a discussion whether indeed all the Romanes speakers were protected under the Charter, and then the weak protection of Chapter 2, or only those Romanes speakers where it is proven that they were already present on the territory of the state since more than 100 years, because some authorities argued some of the speakers came only later. We had this discussion as well in respect of Finland, where we were discussing about the Karelian language and the Russian language. Then at the end, it was concluded all the speakers should have the protection. And then an interesting point is that sometimes states argue, yes, indeed, this language was spoken on the territory already more than 100 years ago, but they were not permanently present. And for example, that was the argument not to give protection to Polish in the city of Vienna, although during the Habsburgian Empire, all these noblemen had Polish workers in their houses. But then they said, at a certain age, they returned to Poland, and then the new generation came. Right? Is that also a point to be made? And this point was recently also made in Spain in respect of the Arabic language, in, if I'm not mistaken, Melilla. It was in Melilla or in Ceuta, where the Spanish state said, yes, all these Arabic-speaking people over there are, in far majority, immigrants. And then we said we want to have evidence on that. In the next periodical report, Spain has to give concrete information, because we think that this argumentation is simply not true. Perhaps you could pay attention to this kind of things. And I hope we keep contact, Tim.
Okay, thanks a lot, René. So the last word to you, Tim.
Okay, great. Thanks very much, both of you. So yes, Lorenzo, yeah, so I was thinking about this as I went along and sort of hoping that no one would bring it up here. So thank you, and also not thank you for for raising it. Yeah, no, I think it's a really crucial point that I've glossed over in both the written and the spoken paper. That yeah, I think maybe that is the important question: is does that really have any consequence, as you say? And I think what I've come down to is sort of feeling like I'm potentially being overly sort of formalistic and lawyerly in trying to pick something out about the fact that under the particular heading of the particular articles, the states are talking about measures for particular groups, and there's maybe some significance to that. But as you say, kind of substantively what they're actually offering, particularly like this printing voter information in Vietnamese, yeah, it's not really a very far-reaching measure. I was thinking if Rainer had been here, he would have picked up this point as well. So I was thinking because he wasn't here, I'd get away with it. But no, I think it's important, and I'll try and think it through properly. And then René, thank you very much again. And I would also very much like to keep in contact. I think, yeah, this is something definitely to bring up, probably more in the PhD, I guess, and stuff in the future. The other example I was just thinking of is, I think this came up, as far as I remember, in relation to the Roma in Denmark, that there was a concern over, whether they count as being present for centuries. And I think the Danish argument is that they then disappeared and then came back again, and so they don't count or something. So yeah, there are lots of nice sort of contortions. Oh, and a final thing, Jelena and Lorenzo know that I'm interested in overseas territories and things, and this I think is really interesting in relation to these treaties as well, is whether and how they're applied to, basically ongoing colonial settings. Since you raised the Spanish territories in North Africa, this is also, as far as I remember, in the Dutch reports, this came up as the question of whether the Framework Convention would apply to Dutch overseas territories, and the Netherlands didn't like that idea. But yeah, I think that's a really interesting one, and one that's, to my knowledge, also not been explored too much. So that would something for the future as well.
There's an extremely new development in the Netherlands. It is very likely. There was a session a couple of weeks ago where the Ministry of Foreign Affairs said that there are no objections, in their opinion, to make the Framework Convention and the European Charter on Regional Minority Language applicable for Bonaire. And until now, it was always rejected, but it is likely that an extension still will be proposed before the parliamentary elections. I got information that very likely it will be sent to Parliament in January or February. And for Spain, it is undisputed. It applies for Ceuta and Melilla. But the point is, are there traditional minority languages spoken? And the monitoring body says, we think yes.
Okay, excellent. I think we conclude there. So thanks a lot, Tim, for a splendid paper and presentation, and everyone for joining in the discussion. I really enjoyed it. Indeed, applause to Tim, and all the best with publishing the paper, and of course with wrapping up the PhD. And I hope to see you all in January when we, I think, move to the Middle East, and we have a presentation on the citizenship status, I think, of Palestinians in Israel. So I hope to see you back in the new year. Bye.
Thanks,
Bye.
everyone.